State versus Vusi, Matlala, and others. This is an IDAC case that has been brought to the commercial court. The tender was the contract. The procurement system was the gateway. The network may be the real case still waiting to be prosecuted. This is a narrow, shallow case between Matlala and IDAC. And I am going to spend my time to explain why this is a shallow case. In this recording, we're going to look at all these various topics as we take a deep dive into this IDAC case. For now, please grab a cup of coffee and your favorite drink, because we are going to spend time digging into this case to understand why I am saying it is narrow and shallow. First, we're going to look at the list of the accused, the charge sheet, the state or the IDAC story, how the alleged scheme worked, the plea agreement, the court's response to the plea agreement, understanding the law. What is a Section 105A? What is a Section 204? And what are they both used for? What's next after the court's response? Then I am going to explain why I say this case is narrow. And then we're going to talk about the SAPS IDAC war. And then we're going to talk about the Germain Prim letter questions. Yes, it comes up when we discuss this. So now let's get into it. The accused are Vusi Matlala, his role in the MEDICARE24 scandal, the state allegation that he orchestrated the procurement fraud, his control of companies that are accused number 2 and 3, why the state regarded him as a central participant. Then we have accused number 2, MEDICARE24 district. The company itself is charged because this company is implicated in criminality. And then accused number 3, Laxo brand investment. This is also another company that is charged. So accused number 2 and 3, the director of both companies is none other than Vusi Matlala. The charge sheet, all of the offenses are under Schedule 5. Total count is 7. Count 1, fraud. Count 2 to 4, corruption. Count 5 to 7, money laundering. This is just a simple, narrow, shallow, lean charge sheet. So what is the IDAC story? Why did IDAC bring this case to the courts? IDAC story is that accused number 1, who is Matlala, is allegedly orchestrated the scheme of defrauding the SAPS, controlled the companies that are now accused number 2 and 3, allegedly secured the tender through fraud, allegedly authorized payments that were fraudulent and now are part of the money laundering charges. So this is how count 1 comes about, fraud. Continuing on with the IDAC story, they are saying accused number 2, MEDICARE24 Tshwane district, the company that submitted the SAPS tender and was awarded the contract, received approximately 50 million rands from the SAPS tender in 199 payments, allegedly received those funds through a contract obtained by fraud. Accused number 3, Laxo Africa brand investment, the company the state alleges that was used to receive funds from MEDICARE24, move those funds through additional entities, conceal the source and movement of the money before it ultimately reached the alleged recipient. The story is pretty much in 3 steps. Step number 1, obtain the tender by fraud. The state alleges that Kate Matlala, acting through MEDICARE24, submitted a bid containing fraudulent misrepresentations regarding his qualifications and the capacity. The alleged fraud includes misrepresenting the company's business address, misrepresenting that it had operational infrastructure in all the 9 provinces, misrepresenting that it had the required personnel, misrepresenting that it had the compatible computer system, misrepresenting that it possessed the operational capacity required by the tender, failing to declare that he had prior communications or arrangements with SAP's officials when the state alleges that he and Captain Brian Cartwright were communicating during the bidding process and before the bidding process. As a result, MEDICARE24 was awarded an SAPS contract valued at approximately 228.7 million rands. Step 2, the receiving the funds. Following the award of this tender, SAPS paid 50.3 million rands to MEDICARE24 Limited in 199 separate payments. The state alleges that those payments constitute the proceeds of fraud. So this step here is the one that is count 2 to 4, corruption. And then step 3, pay gratifications. The prosecution alleges that after receiving SAPS funds, Matlala caused payments to be made to Brigadier Rachel Macheng. You remember Rachel Macheng, the ex-girlfriend, the so-called ex-girlfriend. Let me put it that way. The charge sheet alleges that 3 payments were made of 100,000 each, totaling 300,000 rands via Osizweni to Brigadier Macheng. Now, this is where I'm trying not to rant, but we'll continue. As unlawful gratifications connected to her role as SAPS end user who referred members for services and facilitated purchase orders and invoicing. So why did IDAC separate this case from the bigger case? IDAC's decision to separate Vusi Matlala from the broader SAPS procurement case was a strategic prosecutorial decision. Rather than proceeding to trial with all the accused simultaneously, IDAC negotiated Section 105A plea sentence agreement with Matlala and the 2 companies under his control. In return for the guilty pleas, Matlala agreed to cooperate with the state and testify in future proceedings against other alleged participants. According to the prosecution, the objective was not merely to secure Matlala's conviction. The larger objective was to obtain evidence that could assist the prosecuting the other individuals allegedly involved in the procurement scheme. The prosecutor described this as a necessary sacrifice made in pursuit of the bigger picture. Separating the case, therefore, changed the dynamics of the entire prosecution. The strategic consequences of separating the case transformed Matlala's role. He ceased to be an accused number 1 in the bigger case. He became the prosecution's proposed insider witness. Whether that strategy ultimately strengthens the state's case or simply shifts the focus into Matlala's credibility will only become clear as the broader SAPS procurement prosecution unfolds. Now, let's enter into the juicy part of this story, the plea agreement. The plea that IDAC presented to the court was a Section 105A plea and sentence agreement covering all of these accused people or persons. I don't know if companies are considered people. I don't know. The proposed plea is that accused number one, who is Kate Matlala, agreed to plead guilty to count number one and plead guilty to count 2 and 4, which is corruption, plead guilty to counts 5 or 7, money laundering, to Rachel Macheng, admit the factual allegations contained in the plea agreement, cooperate with the state, and testify in future proceedings. Accused number 2, MEDICARE24. The company represented by Vusi Matlala agreed to plead guilty on all the 7 accounts applicable to it, admit that it received 50 million rands from SAPS under the contract fraudulently, admit that the contract had been obtained through fraudulent misrepresentations. Accused number 3 is Laxlo African Brand Investment. The company, also represented by none other than Vusi Matlala, agreed to plead guilty to counts 2 to 7, corruption and money laundering only, admit its role in the movement of the alleged funds from MEDICARE24 to Rachel Macheng. The proposed sentence. The plea agreement proposed that the court, with accused number 1, Kate Matlala, take count 1 to 7, all of these counts for the purposes of sentences, and just put one sentence of 8 years. Impose a term of imprisonment, part of which would be suspended on conditions including no further fraud, corruption, or money laundering offenses during the suspension period, continued cooperation and testimony for the state. If Matlala refused to testify or withdraw his formal statements, the suspended portion of the sentence will be put into operation. Declare himself unfit to possess any firearm ever in his life. Restrict him from leaving South Africa until the end of 2030. That means IDAC ignores the fact that Matlala is already incarcerated for another unrelated matter, because it's assuming that after 2030, because he has this suspended expansion, he's going to be free. Accused number 2, MEDICARE24, and accused number 3, Laxo, were both fined 1 million each, wholly suspended for 5 years on specified conditions. During the argument, the prosecutor explained that the agreement was not simply about sentencing Matlala. The sentence said it had made a sacrifice by agreeing to a more lenient outcome before the larger objective was to secure Matlala's cooperation against other high-ranking perpetrators. The prosecutor argued that any public concern about leniency would be justified by what the state expected to do soon after against those other accused. Now, let's look at the court's response. That is the one that is on the headlines, the one that made me look into this case in detail. Although the plea agreement was presented and Matlala confirmed that the guilty pleas admissions were made freely and voluntarily, the court did not immediately convict and sentence him. Instead, the court proceeded to assess whether the proposed sentence was just as required under Section 105A. The magistrate later indicated that if the parties did not accept the court's proposed sentence, there would be no conviction under the agreement, and the matter would proceed to trial, back to square one, back to the larger case. Here's what the court appears to have focused on. Number 1, the seriousness of the offense. The admitted facts included and SAPS tender approximately 228 million, and about 50, of which 50 million of that tender was paid to MEDICARE24 fraudulently. The guilty pleas to fraud, corruption, and money laundering. The magistrate viewed these as very serious offenses. Number 2, Matlala's role. The court observed that the admitted facts, Matlala was the driving force behind the fraud. The magistrate, and I quote the magistrate, the admitted and agreed facts relating to the charge of fraud reveal accused number 1 to be the mastermind behind the commission of that offense following an advertisement pertaining to a tender. It was accused number 1 that set the plan in motion. That finding matters because it goes to proportionality in sentencing. Number 3, personal circumstances were not strongly mitigating. The court considered his age, family circumstances. They asked him how many kids he has, how many wives, ex-wives, girlfriends, even the one that he wanted to unalive. Time spent in custody, previous convictions, claimed remorse and cooperation. However, the magistrate explicitly stated that none of Matlala's personal circumstances struck the court as substantially mitigating. Number 4, cooperation was recognized but not decisive. The court acknowledged that Matlala had indicated from the outset that he wanted plea discussions, provided information, agreed with investigations into alleged higher-ranking officials. The prosecution argued that this cooperation justified a more lenient sentence because it would help prosecute other alleged participants. The prosecutor even described the agreement as a sacrifice made by the state in pursuit of a bigger picture. The court accepted that cooperation had value, but it still had to decide independently whether the agreement sentence was fair and just. Number 5, the constitutional role. Under Section 105A, a magistrate is not a rubber stamp. Even if the prosecution agrees, the accused agrees, the complainant, SAPS, I don't know if the SAP had agreed to this plea bargain. I don't know. I may have to check if the SAP has actually agreed to this plea bargain. The court must still ask, is the sentence just? If answer is no, the court may propose a different sentence, which is what happened. If the parties refuse that proposal, the plea agreement falls away. The matter proceeds to trial before another court. Why the court rejected the proposed sentence? Reading the judgment as a whole, the answer is the magistrate concluded that the sentence negotiated between IDAC and Matlala was too lenient when weighed against the seriousness of the admitted fraud, corruption, and money laundering, Matlala's central role in the scheme, and the scale of the public funds involved and stolen. That is a legal conclusion about sentencing proportionality. It is different from saying the court rejected the prosecution's case or found IDAC acted improperly. So the judge proposed 12 years. So IDAC, let's recap here for a minute. IDAC proposed 8 years. I think some of it was going to be suspended. And then the court responds with 12 years. If he is convicted, if he goes on trial and gets convicted, it's going to be 15 years. That, according to my research, I could be wrong. You guys can go on the comments and correct me, but that's what it is going to be, like 15 years if he's convicted. So now, you know what? If I was in Matlala's shoes, I would take my chances with the trial. Understanding the law. Section 105A. Why is Section 105 became central in Matlala's case? But before we get into that, let's understand Section 105A is not a mechanism for avoiding justice. I will repeat. Section 105A is not a mechanism of avoiding justice. It is a mechanism for negotiating justice. The final safeguard remains the court, which must independently determine whether the negotiated outcome is fair, proportionate, and in the interest of justice. How does this apply in Matlala's case? Because the law says Section 105A is not a get out of jail card. The prosecution viewed Matlala's cooperation as sufficiently valuable to a just negotiated plea agreement. The court agreed that the cooperation was an important mitigating factor. However, the magistrate concluded that the proposed sentence did not adequately reflect the seriousness of this fraud, the corruption, the money laundering, the scale at which of this SAPS tender. Section 204. Section 204 witnesses are valuable when they provide evidence that investigators cannot reasonably obtain elsewhere. The question is, did IDAC first exhaust documentary evidence, banking evidence, digital evidence, evidence held by other agencies like crime intelligence, SAPS, the Matlala Commission? Did IDAC exhaust that before they actually consider Matlala as a 204 witness? Or did the plea agreement become the primary tool for investigator? So in other words, IDAC is doing a shortcut investigation here. They just want Matlala to sit on the stand and admit that he did this crime with A, B, C, D, whoever the officers are. That's what IDAC is trying to do, and it's not about investigate. Do the hard work to investigate first. That is a question. This is a serious question, guys. A very serious one. What happens next? The magistrate did not reject Matlala's guilty plea. We need to understand this. The court rejected the proposed sentence negotiated between IDAC and Matlala, including that it was not proportionate to the seriousness of the offense. The parties must now decide how to proceed. Option number 1 is to accept the 12 years that the court has proposed. And then option number 2, reject the court's counter proposal. If either Matlala or IDAC rejects the court's proposed sentence, the Section 105A agreement falls away and Matlala goes back into the bigger case. The prosecution would then have to prove every element of fraud, corruption, and money laundering charges in the ordinary course. Option number 3, renegotiate the plea agreement. The parties may decide to negotiate a revised plea agreement that addresses the concerns identified by the magistrate. Any revised agreement would still need to satisfy the requirements of a Section 105A and would remain subject to judicial approval. Whether this option is pursued will depend on the willingness of both parties to continue negotiating. And from what I hear is that Matlala has fired the lawyers in this case. So I don't think he's about to negotiate because he wants a get out of jail card. Option number 4, proceed to a full criminal trial, which I think is most likely. The strategic consequences for Matlala is that he has to decide to accept the longer custodial sentence with certainty. He knows that it's going to be 12 years, or rejecting the agreement and facing the uncertainty of a full criminal trial. For IDAC, the prosecution faces equally significant decision. If the plea agreement proceeds, IDAC secures a conviction, admits the facts, and they have a cooperating agreement. For the remaining accused that are in the bigger case, the outcome of the plea proceedings may substantially affect the remaining accused in the broader SAPS procurement case. If the agreement succeeds, Matlala is expected to become a key witness against them. If the agreement fails, the remaining accused may instead face a prosecution that relies primarily on independent documentary, financial, and witness evidence. They have to look for it. If witnesses somewhere else, it's no longer going to be Kate Matlala. For the broader prosecution, the magistrate's ruling represents a turning point in the prosecution strategy. The court accepted that cooperation had value. What it rejected is the sentence. The sentencing, he said, it is not just. The decision that shapes the next chapter. The court has spoken. The next move is really dependent on Kate Matlala and IDAC. The choices they make will determine not only the future of this plea agreement, but may also affect the course of the broader SAPS prosecution strategy. The Medicare files. The tender was the contract. The procurement system was the gateway. The network may be the real case still waiting to be prosecuted. This is a narrow case in a much bigger story. In the beginning, I said this is a shallow case. The state's prosecution, which is IDAC, against Vusi Matlala and his co-accused, presents a coherent and legally sustainable criminal case. There we agree. It alleges that Matlala fraudulently secured the SAPS Health Risk Management tender through MEDICARE24 Tshwane District Limited, that this company received more than 50 million rands in payments from SAPS, that unlawful gratification was paid to a senior SAPS official, and that portions of those funds were subsequently laundered through intermediaries entities. If proved, those allegations constitute serious offenses involving fraud, corruption, and money laundering. The question, however, is not whether the state has a case. That's not the question. The question is whether, is this the entire case? Is this everything? The SAPS tender was never simply a procurement exercise. Now, let's look at the commissions. Over many months, almost a year, the Matlala Commission and the ad hoc committee in Parliament proceedings revealed a far broader landscape of relationships, communications, financial transactions, procurement decisions, and alleged influence than reflected in this case, in this indictment. This indictment doesn't cover not even a drop of it. This is my frustration with this thing. So unfortunately, I have you guys here, and you're going to have to sit there, take a sip, and listen to me rant. Evidence before the committee extended beyond the 3 accused currently before the court. The Matlala Commission and even the ad hoc as well heard testimony concerning Brown Muhotsi, whose relationship with Kate Matlala says to senior public officials, involvement in matters surrounding this very SAPS tender were repeatedly explored, but he is not charged. It included evidence by Sergeant Fanning Nkosi, who acknowledged forwarding confidential information and official communications relating to Matlala between senior officials, and this SAPS tender was part of it. Sergeant Nkosi is not charged. The hearings also heard evidence concerning Lieutenant General Shadrack Sibia, including allegations that he received impalas as gratification for this particular tender. The movement of information connected to Matlala through Sergeant Nkosi, there's a lot of it. Kate Matlala has a recording also complaining that Sibia is demanding a lot of money from him. Sibia, Lieutenant General Sibia, is not charged. Was he investigated? Evidence concerning General Richard Shibiri similarly formed part of the commission's inquiries, including recordings in which Matlala allegedly referred to providing financial benefits to Shibiri. Those allegations remain disputed and have not been determined by any court, but they nevertheless formed part of the commission's examination. Did IDAC investigate that? The commission also questioned Suleiman Karim extensively regarding payments allegedly received from Matlala, and Karim admitted that he invested his money into this tender. Financial arrangements connected to the SAPS tender and the movement of funds following the award of the contract. Suleiman Karim is not charged. Oh, by the way, he is part of the Indian cabal. I am not going to go there. I'm not going down with Shongwe and Skosano on this Indian cabal thing. No, I'm going to stay out of it. The bigger picture. The hearings traversed procurement officials, intermediaries, consultants, financial facilitators, business associates, and police officers whose relationships with Matlala, the procurement process, and the tender were explored over many months. Viewed collectively, the commission was examining what appeared to be an entire procurement ecosystem. By contrast, the present prosecution focuses on a very narrow, shallow narrative. It seeks to prove how the tender was allegedly obtained through fraud, how approximately 50 million rands was paid under the contract, how 3 alleged payments of 300K, really? How these payments were allegedly laundered? Can we really be focusing on 300,000 rands paid to Rachel Macheng to go and do her Ozempic or what do you call it, this surgery? Really? And when Karim sat right there at the commission and talked about millions that he was moving in and out of Medicare24 related to this very tender, that is undoubtedly a process. I really can't. Does this case represent the complete picture in a separate question if you really think about it? The investigation question, let's go there. The public record naturally gives rise to further inquiries. Were all alleged beneficiaries of the Medicare tender identified? Were all recipients of payments from Matlala investigated to the same extent? Were all procurement participants examined through the criminal investigation? Were all the relevant bank accounts, financial records, intermediary companies analyzed? Were digital communications procurement documentation, and financial intelligence consolidated into a single evidential picture, where investigative resources held by other law enforcement. When I say other law enforcement, I'm talking about the SAPS and crime intelligence. The Dumisani Kumalo that they are busy arresting up and down has the information that they actually need for this case. These questions should not be misunderstood. They are not allegations that every individual mentioned before the Matlala Commission committed the offense. That is not what I am saying. Nor does the appearance in the Matlala Commission evidence automatically justify that you are criminally charged or prosecuted. That is not what I'm saying. The criminal charges require admissible evidence capable of proving every element of an offense beyond reasonable doubt. Nonetheless, the commission hearings traversed and a considerably broader landscape than what is reflected in this case, in this indictment. The difference raises a further question about the prosecution, about IDAC, the integrity of IDAC, their investigative strategies. Let's rewind a little bit and look at the plea question. The plea agreement suggests that IDAC regarded Matlala's cooperation as sufficiently valuable to justify a substantial sentencing concession in exchange for future testimony against other alleged participants. There is nothing inherently improper about that approach. Section 105A plea agreements are a recognized feature in the South African Criminal Procedure Act and are frequently employed in complex corruption and organized prosecutions. The question, now listen to me carefully, the question is not whether the plea agreement was lawful. Yes, the Section 105A is lawful. The question is that, was that plea necessary? Was it necessary? What already exists? Before negotiating a substantial sentence reduction, to what extent did the investigators independently verify and consolidate information already available through financial records, procurement documentation, digital communication, forensic accounting, witness testimonies, other witnesses, not Kate Matlala, intelligence products? This very Lieutenant General Khumalo that they are busy arresting for HR-related matters has all the information that is needed for this case. The real question, if independent evidence already exists, could reasonably have been obtained through further investigation and interagency cooperation, the extent to which this prosecution depended on Kate Matlala's cooperation becomes an important subject for legitimate public scrutiny, and this is exactly what I'm doing. Conversely, if Matlala possessed information that could not reasonably be obtained elsewhere, the plea agreement may represent a sound prosecutorial strategy. The public question, what it does reveal is the distinction between the broader procurement ecosystem explored during the commission's hearing and the narrow criminal case presently before the court. Whether that difference reflects an investigation still unfolding or the final scope of the prosecution remains to be seen. One conclusion, however, is already apparent. The commission, the difference is, now listen carefully, the difference is the commission explored a network, a charge sheet, prosecute just one transaction, Rachel Macheng. Is there more to come? Is this the best that IDAC can do? Is this the best that their investigators, the so-called padayashes and prenmeals, whatever. Is this the best that they can do? They can come to IDAC with just one transaction. One transaction. Russia Mashen's Ozempic. This is what this case is about. The SAPS and IDAC war. In my previous recording, I have gone into a deep dive into that war. If you go on my profile, you can find the recording. All I can say right now, because I've already made a recording about the IDAC and the SAPS war, you can check it on my profile. Could this case, the prosecution, become another arena in that that is an institutional conflict? We already know what Lieutenant General Mkwananzi said when about IDAC wanting to charge Matlala and moving him from Kokstad to Pretoria and all that stuff. We know all about that. So it's not clear whether this case is being prosecuted genuinely or is just being used for as conflict between the two institutions. Before I end my rant, the Germain Prim letter. Do you guys remember that letter? This letter here. The Germain Prim letter should not be viewed as evidence that proves misconduct. I am not even going to go there. It should be viewed as one piece of information that prompted broader public scrutiny and how the plea process was conducted. How was this plea process conducted? The key questions remain. Were the negotiations done by IDAC lawful? Was the plea voluntary? Were proper prosecutorial standards observed? Did the court exercise independent oversight? Those are the questions that ultimately matter. And it's time. It is time. This is the time for Andrea Johnson to go to the inquiry on Ngavinde there. That's where Johnson needs to be, with a team of lawyers. The key takeaway: the Germain Prim letter does not determine whether the plea agreement was lawful. It raises questions that require evidence, independent verification, if necessary, judicial oversight, if necessary. And I've already called this, and I'm going to say it again. Andrea Johnson needs to go to the Nkabinde inquiry to test his ability to hold this office of IDAC, because she has a lot of power in her hands. That distinction is essentially to maintain legal fairness and public confidence in the criminal justice system. Instead, if allegations are accurate, what legal issues would they raise? For example, voluntariness of the plea. Did Matlala enter into this negotiation voluntarily? Legal representation, prosecutorial ethics, witness handling, disclosure obligations, judicial oversight. Enough of my ranting. The network may be the real case, still waiting to be prosecuted by somebody. Please share my content in your profile and follow me to stay up to date with this case, because the next court date is 13 July 2026. This date is very important because the parties must inform the court whether they accept the court's proposed sentence or reject the court's proposed sentence or seek to renegotiate a revised plea agreement. If no agreement is reached, the Section 105A plea agreement falls away and the matter proceeds to a full criminal trial. Sorry for making this long. See you on the next one.